Please be seated. Good morning. Welcome to the Court of Appeals of Maryland. We have two cases on the docket this morning, and we will begin with case number 1, Dzurec versus Board of Commissioners of Calvert County, case number 1 of the 2022 term. Mr. Nelson, please proceed.
Good morning. To please the court, Mason Nelson on behalf of the petitioner appellants. My clients are citizens and taxpayers in Calvert County. I have 4 clients, 2 of whom are with us today, Susan Dzurec and Clara Goins. They've been with me every step of this case from day 1. This case arises out of a decision by the Calvert County Board of Commissioners to approve the new countywide comprehensive plan, the countywide planning document. The ethics ordinance prohibits an elected official from acting on a governmental matter if he has or might have, or she has or might have a financial conflict unless, and there are 3 exceptions in the ordinance, unless they're the only person who's able to act. Second, they're obligated by law to act. And the third is if they step aside, whether that would defeat quorum. We assert that this ordinance prohibited, disqualified Commissioner Kelly McConkey from voting to approve the comprehensive plan, the countywide planning document, because it concerned a piece of property and increased the value of a piece of property or 2 pieces of property that he owned.
Counsel, if I could just interrupt so I'm clear. There was a hearing relative to the comprehensive plan, correct?
There were a series of hearings.
Okay. The latest hearing at issue where it made its way appellate-wise. Can you tell me whether or not this issue was presented during that hearing, i.e. the conflict relative to Commissioner McConkey?
We're talking about the public hearing. There are 2 public hearings. The vote was on June 25th, 2019. The court is asking me, I believe, can I cite to the record whether a citizen at that hearing raised this point? I didn't prepare that point for this hearing, so I'd have to look at the transcript to answer that question. And I don't mean to be evasive, it's just I was so focused on the other issues I hadn't thought of that point. So
Okay. Perhaps during your rebuttal time you might be able to look that up. But the second question is relative to the taxpayer standing.
Yeah.
Was that an issue before the circuit court or the Court of Special Appeals?
Yes, it was.
Okay, and can you tell me why the circuit court? What was the argument that would negate the taxpayer standing? Because it seems to be obvious to me, but maybe I'm missing something from my review.
Well, let me just do it chronologically. The circuit court, initially, the defense, my adversary in this case, asserted standing. So under bill, this is a legislative action, taxpayer standing. We prepared and filed taxpayer standing affidavits for each of the 4 citizens. And the trial court found that they had taxpayer standing. So then at summary judgment, that was the motion to dismiss I was describing. And then at the motion for summary judgment proceeding, we had the legal argument. Defense argues potential conflict of interest is off the table as a matter of law in a legislative matter. That was their defense. And we say we disagree. And we talked about the ulteriors, but at that point, the premise was my clients had taxpayer standing, so we talked about a range of arguments: taxpayer standing, conflict, implied cause of action. My role as an advocate for the citizens was to sort of cover the gamut on defense. So the Court of Special Appeals, there are 2 parts to the Court of Special Appeals' opinion, as the court knows. The first addressed the implied cause of action, and the second was this taxpayer standing. So I feel as if this has been front and center from day 1 in this proceeding. But with respect to the court's question about the administrative hearing. I'll look at the transcript. But rules of preservation, I respectfully suggest, don't apply to citizens at a public legislative hearing to preserve legal arguments. So I would just make that observation.
Okay, thank you.
Okay. Now, let me just touch on the facts, if I might. Kelly McConkey is one of the commissioners. He owned 2 pieces of property that are relevant here in the town, in the vicinity of Huntingtown. And when they're reworking the comprehensive plan, imagine these town centers throughout the county. They were trying to direct development, the more intense development, to the town centers, one of which was Huntingtown. And so there's discussions, what should be the footprint of the town center? There was, the planning department made a recommendation for a certain footprint for the Huntingtown Town Center, which excluded these parcels of land owned by Commissioner McConkey. That was the planning department's recommendation. And then there was another recommendation which had a larger footprint, which just coincidentally included the 2 parcels owned by Commissioner McConkey. The planning department determined that incorporating the parcels into the Huntingtown Town Center would increase their economic value by adding new zoning and development opportunities. So there was a real belief that there were economic consequences to having new land within or without the footprint of the town center. In any event, at June 25th, the court asked whether there were hearings. Yes, there were, but there were, so imagine work sessions. Like it was, it's a big job to do a comprehensive plan. And on the June meeting, there was discussion about the Huntingtown Town Center. And there were 2 proposals on the table. The first proposal was the smaller footprint that excluded the McConkey land, and the second proposal was the larger footprint that included it. And then Commissioner Hart made a motion to have the larger footprint. Commissioner McConkey did not vote. The vote failed 2-2. And the president said, we'll carry that on to the final vote. That was in June. Well, now we're in August, 2 months later, and talking about the overall plan. And there's a renewed vote on the footprint of Huntingtown Town Center. This time, Commissioner McConkey votes. That carries 3-2, and that's subsumed into the larger plan, which was approved 3-2 with the McConkey vote. We assert that he was disqualified from voting because he was not the only person able to act. He was not obliged by law to act. And if he stepped aside, there would have been quorum because there would have been 4 votes. Meanwhile, the court asked whether people raised at this public hearing, legislative hearing, an objection to this. And we'll go to the transcript and answer that question. But they filed an ethics complaint, right? And so now there's this. I was not involved in the ethics case, but now there's an ethics complaint filed with the Ethics Commission. And there was all manner of drama about that, and the Court of Special, there was a litigation, and we just submitted a line with the court, which I believe the court now has. The Court of Special Appeals unreported opinion just came out, I lose track of time, 60 days ago or so, in which they addressed the circuit ruling. But in a nutshell, the Ethics Commission found an ethics violation. The circuit court, Judge Nichols from Prince George's, specially assigned to Calvert, reversed outright. Court of Special Appeals reversed that. The circuit court decision reinstated the Ethics Commission decision.
Mr. Nelson.
I'm sorry.
So, as I understand your complaint, you have filed a complaint for a declaratory judgment.
Correct.
Seeking to declare the, basically, the comprehensive plan a nullity because your position is that Councilman McConkey had an ethics, a conflict of interest, and therefore his vote was ultra-virus.
Correct.
So you are seeking to have this court declare the comprehensive plan to be invalid based on a conflict.
No. I wish I could say that, but the answer is no. That's our relief in our complaint. I think under the state center case, because my clients have taxpayer standing, because they've made an adequate allegation of an ultra-virus action, they're entitled to, in the words of the state center opinion, a merits hearing on the question of the ultra-virus act.
Why are they entitled to a merits hearing? Isn't our case law pretty clear that a conflict of interest doesn't establish an ultra-virus act? In other words, as long as you are acting within the legal boundaries of your position, we don't nullify councilmanic action based on a conflict of interest.
This is where I disagree. So, to me, what's interesting about this case is you have the Sugarloaf opinion from 1990, and it says what Your Honor just said. And then, since 2009, plus or minus, this court has been sort of articulating and refining and writing robust opinions about taxpayer standing.
Taxpayer standing just allows you to get into the courtroom. Taxpayer standing doesn't create an independent cause of action, does it?
I respectfully, categorically disagree with the court and would direct the court to State Center, to the Anne Arundel County versus Bell case, to Floyd and George. But certainly State Center and Bell say categorically that the taxpayer standing doctrine is creates the cause of action, and it gets you into court for the merits hearing, so long as the allegation, you've made an allegation of ultra-virus action in good faith, which my clients have done. So I disagree. If the court believes that that this court's jurisprudence doesn't say that taxpayer standing gives an independent cause of action, I, with all due respect to the court, disagree. I think Bell does, State Center does.
So what are the elements of your cause of action that you are attempting to prove?
Let me just read them. Number one, does the ethics ordinance prohibit a vote in these circumstances? We say yes, because he's got a financial interest in the matter before the commission. All right, so we have that's our threshold point. Then there are three exceptions to the prohibition for voting.
If I can stop you, the way I understood Booth's question, which I have as well, is what are the elements, not what are the facts that you're relying on, but what are the elements of the cause of action that you are proving? As I understand your statement of cause of action, it's the elements are identify an ultra-virus action, and if you identify one that you want the court to strike it down. Is that right, or are there other elements of the cause of action?
No, I think that's it. I mean, I'm looking at the State Center. 438 Maryland, 462, 463. A taxpayer plaintiff must simply, quote, allege in good faith an ultra-virus or illegal act by the state or one of its officers, as was done here, because that was a state case, not a county case. Such allegations sufficient to confer taxpayer standing so as to entitle the plaintiff to get its foot into the courthouse door and receive potentially a merits hearing. So I think that's what we need to do, and that's what we did.
So you got your foot in the door, and nobody's disputing that your foot is in the door. You're here, and nobody has alleged that you don't have taxpayer standing. But in order to prove an ultra-virus act, doesn't the court undertake a very narrow review and simply determine whether the council was acting within its legal boundaries? Isn't that the standard under this court's jurisprudence for determining whether a legislative act was ultra-virus?
My view is a little bit different, and maybe this is good, maybe this is bad, but my view has been informed by Judge Harrell's writing, and I'm struck by something he wrote in Superblock 1, 407 Maryland 253 at page 267, this was in his dissent, but it was on a point that wasn't in controversy. But he's talking about Sugarloaf case. Just fascinating to me. Here is 2009. He's sort of predicting that at some point down the road, this issue is going to come to the court. And this is what he said. This is Harrell in 2009, Harrell in 2012, discussing the Sugarloaf case. In Sugarloaf, we did not specify exactly what type of ultra-virus action by a public official a taxpayer could suit or restrain. In fact, this court has never drawn any strict lines. Rather, taxpayer standing protects taxpayers potentially affected by the adverse public decisions that impact their homes and livelihoods by granting taxpayers authority to challenge acts of public officials that are outside of their authority, even when another public official, such as the Attorney General, is empowered to bring the lawsuit but fail for whatever reason to do so. So I think what Judge Harrell is saying there, and State Center follows up on this, and Bell case also, that if there's an evidence of an ultra-virus action, good faith allegation of it, you go into court and have a merits hearing. What we had was a summary judgment legal argument on whether the trial court could even consider a potential conflict of issue under Sugarloaf.
Well,
Go ahead.
how do we determine what's an ultra-virus act? What's the test for that?
I think my answer to that question is we look at the ordinance. And the first question is, did he have a financial interest in the footprint of Huntington Town Center? We've made a good faith allegation that he does. Then, at that point, he's prohibited from voting unless, if it pleases the court, unless he can show that he falls into one of the three exceptions. One, he won't break quorum, not applicable here. Two, he's the only person who can vote, not true here. And number three, he's obligated by law to vote. So, my answer to the court's question is that's how a fact finder in a merits hearing would address that issue as to whether it was or was not.
But hasn't our case law specifically under Kenwood and Sugarloaf held that your client may have a valid complaint under the ethics ordinance, but simply establishing a conflict of interest does not create an ultra-virus legislative act such that this court has the authority to void it?
Well,
does it?
Let's take Kenwood, for example. Kenwood's Baltimore County case was a planned unit development. To get a planned unit development, you need to get a legislative action to approve the PUD. Now you have legislation. You need a council person to introduce it, and it needs to be passed. And that creates a mini zoning ordinance that's going to control the development of this property. So what was at issue in Kenwood was that the developer made an illegal donation to the council person who sponsored the legislation to generate the PUD. Now, fast forward, there's a traditional administrative land use proceeding as to whether or not the application satisfies the required findings for the PUD. The ALJ and the Board of Appeals found that it did. Carol Holzer, on behalf of the citizens, was arguing vigorously, wait a minute, there's an illegal contribution, and the ALJ said, the Board of Appeals said, the Circuit Court said, and the Court of Appeals said, it's not part of the quasi-judicial, it wasn't one of the required findings for the approval of the PUD. It was an unrelated legislative piece. So to me, Kenwood has no relevance to this case. Sugarloaf, I've read Sugarloaf so many times, but and I've learned from their mistakes. Well, Montgomery County had a provision on which the citizens relied to say, if the trial court thinks it's in the best interest to strike it, they can do it. The court said no. They struck that. So that was the basis of the citizens' case.
But that's what you're asking us to do here.
No. I respectfully disagree. Here we have an ethics ordinance which prescribes a course of action.
But there's no remedy in the ethics ordinance to say, like Montgomery County, which was struck down as unconstitutional, that if you violate the ethics ordinance, a court, which is what you're asking here, can strike down the legislative act as being ultra-virus. Isn't that what you're asking?
I'm not asking this court to strike down the legislative act. I'm asking this court to give what state senators said my clients are entitled to, which is a merits hearing on the case.
But what would that merits hearing accomplish? I mean, aren't you asking us to effectively assume, well, now we have the Court of Special Appeals opinion, but let's say there was a conflict. Let's just, from that premise there, isn't it just a question of law as to whether or not the conflict creates an ultra-virus act?
I think it's a question of law, but we never had that. I see I'm out of my time here. There have been a lot of questions.
You can certainly answer Judge Wood's question.
The circuit court ruling turned on the notion, the question, can we even consider the conflict? The court said, reason, no, they accepted my adversary's argument, no, we cannot. Our assertion, if it pleases the court, is that premise is flawed, that in the context of this ethics ordinance and this taxpayer standing doctrine as refined by this court since 2009 allows us to get into court and argue and get a merits hearing, and then if we prevail at the merits hearing, we will argue that the legislative action should be set aside. So I'll save my 10 minutes. Thank you for all the questions. It's an interesting question. Appreciate it.
Okay, you will have the 10 minutes you reserved for rebuttal, and we'll hear now from Mr. Mattingly.
The courts may not invalidate legislation on the basis of a conflict of interest. May it please the court, John Mattingly on behalf of the Board of County Commissioners of Calvert County. The true heart of this case is a constitutional question, that question being the separation of powers. The adoption of the Comprehensive Plan is a purely legislative act. On that, there's been no dispute in this case. Accordingly, the court's authority to void this legislation is very narrow, and this court has previously held that the courts may not invalidate legislation on the basis of a conflict of interest. The present matter begins and ends with two cases from this very court, which are directly on point. Sugarloaf, which is a 1990 case, and Kenwood Gardens, which is a 2016 case. This court in Sugarloaf specifically struck out provisions of a Montgomery County ordinance which ceded legislative authority to the courts upon a finding of a conflict of interest. And this court further held in that case that the invalidation of legislation for a conflict of interest was improper. Kenwood Gardens...
Was it that invalidation in any sense would be improper, or was it the fact that the courts were given the authority to decide in the interest of justice whether to do it? You seem to be making an argument that it would always be improper to have a legislative provision permitting invalidation of a legislative act for a conflict of interest. I haven't read the cases as saying that, but that provision that allowed the court to determine whether it was in the public interest to invalidate it was improper.
This court in Sugarloaf said, well, what's happening once you make this finding that there was a conflict of interest? We're placing the court in the shoes of the legislative body and saying, okay, well, this is how we're going to reform this legislation. And that obviously was a violation of separation of powers. I think when we looked at to the what I call the second part of this, which is Kenwood Gardens, they more succinctly spoke to the separation of powers issue, which, and once again, it did repeat in Kenwood Gardens this concern for the separation of power, well, I shouldn't say concern for the separation of powers. You came out specifically and said there was a separation of powers issue here. But it held that it wasn't appropriate for the judiciary to review legislation for conflict of interest, because what's happening is we are now allowing one branch of the government to invade the legislative branch, another branch. So Sugarloaf and Kenwood Gardens, I would argue, are the alpha and the omega on this conflict of interest question. So the next question is whether this court will overturn established precedent. But this really isn't the case to do that. Frankly, this case is all over the place, with changing legal theories and theoretical questions lacking the necessary factual support. For instance, there's never been a finding of a conflict of interest in this case, period. Dzurec assumes and alleges a conflict of interest, but there's been no such finding. Now Dzurec would point to an ethics commission decision which has been ping-ponged back and forth between the circuit court and the appellate courts. But even that's not a final decision yet. So most importantly, the county is not a party to that Ethics Commission case. And let me say this again because it's very important. The county is not a party to the Ethics Commission case against Commissioner McConkey. So because it's different parties, any decision in that case has no conclusory effect on this case. The point being, without so much as a finding of a conflict in this case, there's nothing to warrant overturning established precedent. Now, at this point, as we heard, it seems Dzurec still hasn't decided what kind of case they're bringing. Throughout the Court of Special Appeals, throughout the petition for writ of certiorari, and even through the beginning pages of their opening brief, they presented two questions. The first question, and I quote, whether Commissioner McConkey's vote to enact the comprehensive plan was ultra vires, where he voted in violation of the Calvert County Ethics Ordinance, and where that vote was the deciding vote, end quote. Now, ignoring the fallacy of the deciding vote and ignoring the fallacy of the ultra vires vote, at least this question was preserved for appeal. The second question Dzurec posed, and I quote, was whether the Calvert County Ethics Ordinance includes an implied cause of action for citizens with standing. Now, starting with this implied cause of action question, this issue has always been a head scratcher because the county has never at any stage of this litigation opposed or briefed this question of the implied private cause of action. Bizarrely, Dzurec continues to raise this issue. And the reason the county has never opposed this issue is because the issue is irrelevant. This court has said specifically that this is an irrelevant inquiry. In State Center versus Lexington Charles, this court said, and I quote, because taxpayer suits in this state do not require a separate private right of action, such an inquiry is irrelevant to our analysis. 438 Maryland at page 456. So now Dzurec tries to shift the argument and make this case somehow morph into a case about taxpayer standing, but not just standing. They argued that taxpayer suits have this whole entirely different jurisprudence unto itself. So the problem here with this new taxpayer standing argument is that one, it wasn't properly preserved, and two, you can't appeal a favorable ruling. The circuit court held that Dzurec had taxpayer standing. They prevailed on that issue in front of the circuit court. They're not aggrieved, so it's not properly before this court.
Well, it seems like the argument is not whether they had taxpayer standing, which everyone agrees they do, but what that means. In other words, if they have taxpayer standing, whether or not that allows them, as your opponent says, to get the merits hearing.
Absolutely, Your Honor. And I guess the frustrating point from my standpoint is in their opening brief, what they requested was that this court make a factual determination and assess whether McConkey violated the ethics ordinance in his vote. This whole idea of this special merits hearing doesn't even appear until page 3 of their reply brief. It's this issue, it's this moving target that the county has to keep trying to shoot down. And it's been this way from the beginning of the litigation. There's ever-changing theories on how they're going to prevail in this case. And the reality is, the case comes down to Sugarloaf and Kenwood Gardens, and they still haven't rebutted that. So, once again, I would argue, and the county would argue, that this issue of this special merits hearing has never been preserved. And quite frankly, the bigger problem is they did get a merits hearing. On January 22nd, 2021, we had a half-day hearing on this. They didn't prevail, but they did have a hearing. They could have put forth anything they wanted. So, I guess, taking a step back, what Dzurec attempts to do is characterize this court's holding in State Center versus Lexington Charles as a guarantee of a merits hearing. So let's take a step back. The actual relevant statement in State Center was, and I quote, such allegations are sufficient to confer taxpayer standing so as to entitle the plaintiff to get its foot in the courthouse door and receive potentially a merits hearing, all other things being equal. That's at page 556. The key words are potentially and all other things being equal. This is not a guarantee for this special merits hearing that they now contend they were denied. Motions for summary judgment apply to taxpayer standing cases just as they do to any other action. The county properly proved there was no genuine dispute as to a material fact and that we were entitled to a judgment as a matter of law. Nowhere in Rule 2-501 does it state that taxpayer cases are immune to summary judgment, and nowhere in this court's opinion in State Center does it say you can't have a summary judgment in taxpayer suits.
Mr. Mattingly?
Yes, Your
Mr.
Honor.
Mattingly, is one of your points that the argument that this holding in State Center guarantees a merits hearing, that was never argued in the circuit court? and before the Court of Special Appeals.
It is now, Your Honor, because quite frankly, this merits argument first appeared in their reply brief. So the first thing I would state is that it wasn't properly preserved, number one. But number two, they did get a merits hearing. And number three, I think State Center is very clear that there's no such thing as this guarantee. What this court said was that all things being equal, you potentially get a hearing. I'm sorry, I didn't mean to scream on that. I'm sorry, Your Honor.
The Court of Special Appeals' opinion addresses the implied right of action extensively. And there appears to be no discussion at all of any allegation that taxpayer standing gives a guaranteed right to a hearing, or that regardless of the court's ruling on the implied right of action, there's this fallback of taxpayer standing that gets us to a merits hearing.
Yes, Your Honor. They have argued, Dzurec argued extensively that there was this implied private cause of action. The county's position from the beginning of this litigation is once you prove taxpayer standing, it's an irrelevant inquiry, and we never briefed it further. So whether it's been preserved or not, I would say no. I don't believe that they can actually appeal a favorable ruling. They weren't aggrieved, and certainly this whole idea of this merits hearing is brand new.
It seems like they're trying to expand, though, not appeal, but expand the meaning of the ruling.
I would agree. It's now taxpayer standing cases are this new separate jurisprudence unto itself with its own distinct elements. I guess the most troubling aspect is they ask this court just to accept the allegations that they make, and that's enough to get them through the threshold of motions for summary judgment, etc. It's almost as if they make the allegations and they're entitled to a trial, I guess potentially in front of a jury. I don't know. I guess for a declaratory judgment it would just be a judge. But once again, it's this moving target that the county's been presented with.
One of the points that petitioner makes is that this case, unlike Kenwood Gardens and Sugarloaf, involves an allegation or an ethics violation of a statute as opposed to a common law ethics duty. Can you comment on that, or is that a distinctive point?
It's not distinctive from Sugarloaf, because Sugarloaf was also a ethics violation. And I think if we look at Sugarloaf and Kenwood Gardens, this court was very clear that there is no common law invalidation of legislation for conflict of interest. When we look at especially when we look at Sugarloaf, what Sugarloaf says is the ethics ordinance actually allows the court to invade the province of the legislative branch and puts the court in place of or in the shoes of the legislative branch. So obviously, in that case, the ordinance was struck down as unconstitutional. I would like to make a comment as to taxpayer standing cases and the fact that they really are like any other case. The only thing that really sets them apart is standing. And Dzurec did get standing. They did get their foot in the courthouse door. I'm not sure about the rest of this jurisprudence they're now bringing up, but the way I read Bell and State Center, et cetera, is really the only thing that sets a taxpayer case apart is standing. Now, finally, there is something that gets lost.
Well, just to take that and the earlier questions that were raised with respect to the elements of a cause of action for taxpayer standing, if the issue here were that the Board of County Commissioners had purported to create a plan for an area that was in Charles County,
Okay.
So no authority to do that. If the allegation had been taxpayers coming in to challenge that, what would they have to prove?
In that case, it's very simple, because that falls under one of the two exceptions for invalidation of legislation, because obviously the enabling legislation from the legislature says, Calvert County Commissioners, here's what you're allowed to do. You're allowed to, under 3-204, you're allowed to approve a comprehensive plan that comes up from the Planning Commission.
So something truly ultra-virus, meaning they just had no authority to do it. You just have to, they would have to come in and just prove that.
Correct. It's for local legislation, and I will admit that it's ultra-virus is a lesser hurdle because all you really have to do is show a deviation from the legislature's enabling legislation. So in this case, for instance, the perfect example in this case is prior to 2013, the Land Use Article 3-204 only allowed the Board of County Commissioners to approve or deny the recommended plan that came up from the Planning Commission. After 2013, the legislature said, okay, you can modify it, which happened here. So if in 2012, the Board of County Commissioners modified a recommended plan from the Planning Commission, that would have violated the enabling legislation. It would have been ultra vires. It could have been invalidated.
Potentially another example could be if two members of the Board of County Commissioners convened a meeting and adopted the comprehensive plan by themselves.
Absolutely, absolutely. Oh, that one's with all kinds of problems, but yes, Your Honor. There is something that gets lost. It's a kind of a losing the forest for the trees situation, and certainly I'm guilty of this as well, and that is the invalidation of legislation itself. A court can invalidate legislation if it is, one, unconstitutional, or in the case of local legislation, if it fails to comply with enabling legislation. We know that the comprehensive plan is constitutional and that part has never been disputed in this case. We also know that the comprehensive plan is not ultra vires, as is specifically authorized by Title III of the Land Use Article. What Dzurec argues is that McConkey's vote, his vote, was ultra vires. Now, that theory would require a third recognized instance where a court can invalidate legislation. The recognized invalidation for ultra vires means that the legislation itself has to be ultra vires. Now, that having been said, and contrary to Dzurec's assertions, McConkey's vote was not ultra vires. And parenthetically, Dzurec does not offer a single case which states that a vote in and of itself can be ultra vires. But for the sake of argument, let's say that his vote could be ultra vires. So be it. That still doesn't fall within one of the two recognized situations for invalidation. There is no recognized invalidation under Maryland law for one of the legislators who voted for the legislation. Invalidation goes to the sausage, not to how the sausage was made. There is no statutory law or case law supporting the idea that an individual vote can be ultra vires for otherwise constitutional and properly enabled local legislation. The reality is that under this court's holdings in Sugarloaf and Kenwood Gardens, courts will not invalidate legislation for conflicts of interest. Moreover, this simply is not the case upon which to overturn established precedent and invade the separation of powers between the branches of government. For these reasons, we'd ask this honorable court to affirm the judgment below.
Okay, I see no further questions, so thank you, Mr. Mattingly.
Thank you, Your
Nelson, you have the 10 minutes you would reserve for rebuttal.
Judge Houghton, during the argument, I looked at the extract. We had just portions of the public hearing in the extract where the votes were taken, so I apologize, I can't answer with precision the court's inquiry, but I will say that we raised it every step of the way. My clients filed an ethics, or citizens filed an ethics commission complaint, and so that's the best I can do.
Thank you for looking.
I think Judge Watts asked a question about the Court of Special Appeals opinion, and I believe Judge Watts asked whether that court only addressed the implied cause of action argument, and that court did address the implied cause of action in the first roughly 50% of the opinion, but the second half, or the second third of the opinion, addressed the other issues that were I've spent most of my time arguing about today, and the core argument is that the Sugarloaf case was not concerning, did not address an ethics ordinance. It addressed what do you do in a situation where the court has excised from the ordinance the provision that gave the court the ability to do something about the illegal vote. And the court said there's nothing in the common law that authorizes the court to challenge that decision. Our case is different. We have an ordinance which spells out with precision what must be done. We assert that the vote was ultra vires. We assert that...
Well, it does spell out, the ethics ordinance does spell out with precision what should happen, and provides a mechanism for challenge, and it allows for a cease and desist order, and it allows for those repercussions for the individual, but it doesn't allow for invalidation of the act or the legislative act that was voted upon. Why shouldn't we see that as an indication that the legislative body didn't view that as an appropriate consequence and didn't want to authorize the courts to take that back?
I understand the court's inquiry. I think under this court's taxpayer standing jurisprudence, that this court's cases since 2009 have been articulating the view that the whole point of taxpayer standing is to allow citizens to take actions such as the action my clients are taking in this case. But also, I do believe that might be a question for another day, because what we assert is under state center, we're entitled to a merits hearing. My colleague argues to the court, Nelson had a merits hearing. No, we didn't. We had a summary judgment proceeding where the trial court ruled as a matter of law in effect that under Sugarloaf, the circuit can't look at these issues.
But why isn't it a question of law if our jurisprudence says even if you can establish a conflict of interest does not constitute ultra-virus action by which we the court, can invalidate a legislative act? So why isn't it a question of law, and why wasn't it appropriate for the circuit court to enter a declaratory judgment? I guess I'm trying to figure out what you're going to do at the merits hearing.
My view has been informed by Judge Harrell's statements. All I can do is read the opinions and read the words. And I read what Judge Harrell wrote about the very case you and I are talking about right now, Sugarloaf. And he's talking about it at 426 Maryland 14 at page 57. Taxpayer standing protects taxpayers. First he says, we didn't specify in Sugarloaf what type of ultra-virus action by a public official a taxpayer could sue to restrain. My personal view is Harrell looked at Sugarloaf, saw and thought about that decision in the context of this evolving jurisprudence on taxpayer standing, and he was trying to set the record straight. And then in state center, he says the goal here is to clarify the doctrine. Those are his words, not mine. Clarify the doctrine. And the doctrine says unequivocally in state center and in Bell that it creates the cause of action to allow a citizen to go into court and present this ultra-virus action. Now, my colleague argues to the court, well, a vote can't be ultra-virus. Well, I disagree. That vote was ultra-virus. Everybody knew it.
Mr. Nelson, in state center, language that the court did not in Sugarloaf specify the type of action that a taxpayer could do to restrain. That may be there, but what is missing is that the court does not say in state center that we're overruling Sugarloaf, that we're now agreeing that a taxpayer can contend that an ethics violation is an ultra-virus act. That language in state center fairly can be read to only indicate the court is now going forward to describe what type of action in state center, namely a violation of procurement laws, a taxpayer can proceed upon, but not to abrogate Sugarloaf.
The transmission wasn't perfect, but I'm going to respond to what I think Your Honor said. If I missed it, please clarify. I understood the court to say, what about Sugarloaf? So, and how does your case differ from Sugarloaf? These are my interpretation of your question. Sugarloaf asked the question, does Maryland's common law allow us to consider this conflict of interest? Does Maryland's common law allow us to do it? Answer, no. That's Sugarloaf. In this case, the question is, does the ethics ordinance, the statute, The county ordinance authorized the court to look at this question. And I respectfully suggest the answer is yes. And I respectfully suggest further that what Judge Harrell was trying to say in the Super Block 1 case is that he was trying to make the point that the Sugarloaf opinion was not the final word in the subject, and there are different ways to address it with taxpayer standing. That's what I believe.
In Sugarloaf, what was the basis on which the plaintiffs were able to make their claim? How did they get there for the court to consider whether there was a common law right to invalidate the action?
This was a reincineration facility in sort of the rural part of Montgomery County.
Right, but what was the basis for their standing?
And one of the voters, this was before it had they were county commissioners, one of the commissioners had a conflict. He sought in advance leave to vote. He was granted that leave to vote. Then a new proposal came in and didn't seek leave again. It was a different proposal. He still had the conflict, voted anyway. The plan was approved. The citizens filed suit in the Circuit Court of Montgomery County, and the Montgomery County ordinance had a provision, and Cnty, I'm doing this from memory here, but in effect it was if the court looks at the conflict and it's in the best interest of the court, it can strike it.
And that the court struck down so that they didn't have a right to invalidate it under the ordinance,
right,
under the ethics ordinance.
Right.
But the court went on to look at it as a common law claim, and what was the basis for their standing to effectively bring that, to look at it as a common law? Wasn't it effectively taxpayer standing before it was, without calling it that?
I've spent a lot of time thinking about that, and it's murky. You know, like you look at the Court of Special Appeals, they say one thing. Look at the Court of Appeals, you say another. It's murky. You look at Harrell's opinions, and I feel like he's saying different things at different times about whether it's taxpayer standing or not. I think a person of good faith could argue maybe it was, maybe it wasn't. But it wasn't presented as squarely and precisely as I'm doing here, where I have an ordinance which says you can't vote. There was a vote. We are putting this front and center. We were relying on language in Bell. We're relying on language in State Center. My clients, we respectfully suggest, deserve a merits hearing, not a hearing where the circuit court, in good faith, read Sugarloaf to be applicable to these circumstances when, in fact, it was not. So for all those reasons, my clients are grateful for the court's granted certiorari, and we appreciate the court's work on the case. Thank you.
I see no further questions from the court, so thank you both for your arguments. Case number 1 of the 2022 term is submitted.